Good afternoon, everyone. We are students from the Institute of Law, Nirvan University, and we are here to talk about a movie review. This review will be about a movie called Pink, which was released in 2016. And this review will predominantly talk about how Indian Penal Code, the Code of Criminal Procedure, and predominantly Indian evidence law is related to this movie. I am Mahimna Dave, and in the later part, my friend Agrim Tandon will take over and throw some more light upon it. So, before moving further, I would like to mention here that the first two parts of this movie review, that is, introduction and the relation of this movie with the Indian laws, will be dealt by me, and further, Agrim Tandon will throw some more light upon how Indian evidence law is relating to this movie. This blog entails a comparative evidentiary commentary on a Bollywood movie called Pink and the Indian evidence law. This movie presents the new types of evidence at trials, which often creates a mismatch with the conventional evidence law in practice. But as a viewer, when we step back and take a look at the bigger picture, it enthralls us by making us realize that it has subtly expanded the horizon of scope of practices in Indian evidence law. The film synopsis: the movie revolves around three middle-class working girls named Meenal, Falak, and Andrea. With the beginning of this movie, we get to know that all the three girls went to a rock concert where they met a group of three boys named Rajveer, Dumpy, and Vishwa. The girls enjoyed the company of the boys and went to have dinner with them. However, things take an ugly turn after the dinner and drinks when Dumpy tried to touch Andrea inappropriately in a room and Rajvi in the other room tried to force himself onto Meenal despite her clearly saying no. In the heat of the moment and acting under self-defense, Meenal picks up a glass bottle and smashes it on Rajvi's head, injuring his one eye. All the three girls immediately rushed out from the scene and returned to their home hoping that the boys would forget about the incident. But the matter escalated when the boys filed a false FIR against the girls, accusing them of assault and labeled them as prostitutes. The matter then went to the trial, where the girls were defended by renowned lawyer Deepak Sehgal, which was played by Amitabh Bachchan. The movie showcased the entire trial proceedings where both the prosecution and defense submitted their arguments and evidences. This blog would specifically review the courtroom trial depicted in the movie and would point by point discuss the relevancy and admissibility of all the arguments evidences presented on the basis of Indian Evidence Act 1872. Proceeding further, the prosecution side to the case tried to establish that the girls went with the boys with the purpose of soliciting, but when the boys refused, Meenal attacked Rajvi with the bottle. The girls were charged under Section 324 of the IPC, causing grievous hurt. Section 307 of IPC, that is, attempt to murder, and Section 8 of Immoral Traffic Prevention Act 1956. The defense pleaded that the act was done in self-defense and the boys were trying to touch them without their consent and the girls were not involved in any cause of action. Section 5 of the Indian Evidence Act says that evidences should be given only to prove the existence or non-existence of the fact in issue or any fact declared to be relevant under the Act. At the beginning of the trial, the prosecution first called the investigating officer for examination in chief, and after the examination in chief, the defense was given the opportunity to cross-examine the investigation officer, but the defense refused to cross-examine. The scene was in accordance with Indian Evidence Act. Section 138 of the Act states the order of examination of witness and mandates the witness must be examined in chief and then it should be cross-examined if adverse party desires. The prosecution then called the doctor of Rajvi, who told about the intensity of the attack. He told that if the glass would have pierced any critical artery in head, then it could have killed Rajvi. The statement is admissible as evidence as it helps in proving the charge of grievous hurt and attempt to murder, which is a fact in issue. So after this, my friend Agrim Tandon will take over and talk more about on this. Thank you.
So after the examination of the doctor, the prosecution then called the waiter of RS Resort for examination in chief. RS Resort was the place where entire incident took place, and then the waiter explained whatever he saw that night in the resort. He told that each girl went to a separate room with a boy. Now, this fact that each girl went to a separate room would be relevant under Section 14 of the Indian Evidence Act because it helps in establishing the intention of the girls. And Section 14 specifically says that any fact which could help in establishing a state of mind such as intention or ill will would be relevant under the section. Also, it is important to note that the statement which is given by a waiter would fall under the category of oral witness and would be admissible as it is in conformity with Section 60 of the Indian Evidence Act, which says that every oral evidence should be direct, which means that he should have seen that with his own eyes, which is Andrea for examination. And the prosecution directly asked Andrea that from how long was she involved in soliciting, to which the judge immediately told Andrea that she was not compelled to answer this question. This means that the judge exercised his discretionary power which is given to him under section 148 of the act, which says that the judge has a power to decide whether a question asked is proper or not and whether the witness should be compelled to answer the question or not. However, it is important to note that section 148 is applicable only in those cases where the question asked is not related to the matter in issue and is asked with the sole purpose of injuring the character of the witness. But in this case, the question asked was directly related to the matter in issue, that is soliciting, and therefore the judge examining Andrea, prosecution next called Falak for examination. The prosecution established the fact that Falak was the sole earner in her family and was continuously in need of money due to her various expenses. Now, this fact that she was in need of money would be relevant under Section 8 of the Indian Evidence Act. Section 8 says that any fact which shows or constitutes a motive or preparation would be relevant under this section. Now, the need of money could be a motive. After that, the prosecution called Rajveer for examination in chief. Now, while examining Rajveer, the prosecution was continuously asking leading questions from the witness, to which the defense objected, and the judge immediately ordered the prosecution to not ask leading questions from the witness. Now, judge gave this order because section 142 of the Indian Evidence Act mandates that no leading question should be asked from witness. The prosecution then called a member of the society in which the three girls used to reside. The person told the court that many boys used to visit girls in their flat, which shows that the person was called with the sole purpose to testify the character of the girl. After the examination in chief of that member of the society, the defense then cross-examined him, which is permissible under section 140 of the Indian Evidence Act, which allows the defense to cross-examine a witness. Finally, the defense called Meenal for examination in chief. Meenal told court that that night Rajveer was continuously touching her inappropriately, and to which she objected. She also told that she, despite of her clearly saying no, Rajveer didn't stop and continued touching her inappropriately. She told that in heat of moment and in anger, she picked up the glass bottle and hit Rajiv to free herself. Now, this fact would be relevant as it could help in proving the plea of self-defense, which is a fact in issue. Thereafter, prosecution cross-examined Meenal. Prosecution showed a photograph to the court in which it was clearly visible that Meenal was herself preparing drinks for everyone. Now, this fact that she was herself preparing drinks would be relevant under Section 8 of the Indian Evidence Act, because Section 8 says that any fact which shows or constitutes a preparation would be relevant under the section. After cross-examining Meenal, the prosecution then showed a CCTV footage to the court. The CCTV footage clearly showed that all the three girls, that is Meenal, Andrea and Falak, were discussing something in the resort, and soon after the discussion, Andrea went with Dumpy to a separate room. Now, this entire fact would be relevant under Section 10 of the Indian Evidence Act. Section 10 says that whenever there are reasonable grounds to believe that there was some conspiracy, and then when one person of that conspiracy does something in furtherance of the common intention, then that act would be sufficient to prove the entire conspiracy. In this case, there were reasonable grounds to believe that the three girls were there to extort money from boys in exchange of sexual relation. And when after discussion Andrea went to a separate room with Dumpy, that act of Andrea would be sufficient to prove that there was a conspiracy.